do the courts decide guardianship or temporary guardianship? Well, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a focus primarily on family law issues here in Michigan. And today we're going to continue our video series that's designed to educate and inform the public, so please subscribe to our channel. So how does the court make decisions about guardianship? Well, here's the interesting thing about it. A lot of times the court makes those decisions because there's no real decision to make. I'll give an example. You have 3 siblings. Only one of them lives in Michigan, and an elderly parent lives in Michigan. And the elderly parent has experienced degeneration, physical decline, mental decline, early stages of dementia. And so the person is in need of the help. The person needs somebody to help them out, help them make decisions, help them pay bills, help them do this, help them do that. So, you file a petition for guardianship. The guardianships tend to be temporary anyway. I mean, the idea of guardianship is that there's a condition right now that we're dealing with. If the condition would reverse and the person doesn't need a guardian, the court would, dissolve the guardianship. In the example that I just gave you, it's not likely to happen when we have elderly people, they're declining. They're not likely to all of a sudden have this sudden flight to health. It's not likely to happen. More likely than not, there's going to be further declining as time. But you see, in the scenario that I set up, where you got someone in Michigan, elderly parent in Michigan, and let's say 2 siblings, one in Arizona and one in Hawaii, it's not a very complicated decision for the court to make, to decide, you're bringing an application, it's your dad, we get it, there's no opposing petitions, we're going to grant this a guardianship for you. It's not all that difficult. Sometimes the scenario is a little bit different, where it's involving a child, and maybe the child is in need of a guardianship, and the court can decide whether the circumstances support, at the very least, a temporary guardianship until people can get back on track. Where it gets a little bit more complicated is where you have, let's say, 2 children, both live local, an elderly parent, for example, and now we have 2 competing petitions. One wants to be the guardian, the other one wants to be the guardian, and you could say, well, great, the court will make them co-guardians, right? Simple. The problem is, what happens if they don't get along? What happens if the reason why sibling B filed a competing petition with sibling A is because B doesn't trust A? B thinks that A's been stealing from the father, been doing whatever. In that situation, the court has to conduct a hearing to determine what's in the best interest of the ward being the person for whom the guardianship would apply, and the court will decide based on that whether or not A should be the guardian, B should be the guardian, or whether or not neither of them should be guardian, and the court can go to an outside service and have one of the guardian care services become the temporary guardian of such person. If you have any questions about this, reach out, and we'll be glad to help you out.